go ahead and get started if we could, please. John Maddox, you're going to help us with Sullivan versus Baptist Hospital a minute, correct? And Lauren Joyce. No, Miss Joyce. Daniel Bullington. No, Mr. Bullington. Maggie Lynch. Miss Lynch. How about Hustler versus Falwell? Miss Epstein. Anna. How about Ward versus Zalakovsky? Caitlin Hutchins. Miss Hutchins. Ferguson versus Union City Daily Messenger. That's probably as far as we're going to get. So to bring us back up to speed, let me ask you, what did you learn last week about the law that you did not know? Anything. Something big, something small, anything at all about defamation. Yes, sir.
Don't understand what's being said about you.
If you don't understand what's being said, I didn't hear the last part. Okay. Yeah. There's no valid publication if the information wasn't disseminated to at least one third person who understood it in its defamatory sense. And so if the third person hears it or sees it, reads it in a language they don't understand, there's no defamation, even though the communication itself may well have been defamatory. What else?
Libel is written and slander is spoken.
Yeah, for the most part, that's correct. We'll make some distinctions between the two here in just a few, but generally that's correct. What else? Yes, ma'am.
Mere name calling doesn't count as defamation.
That's right. You can call people ugly names, very ugly names, as we're going to see here in a bit. But that's not illegal. That's protected speech. What's not protected speech is stating a false fact about someone. That is tortious. What else? These are all great.
If you use someone's defamation and that court asks you whether or not it actually happened, don't say, I don't know.
Why?
It came up in after a man's case. He accused him of stating something false, and when they asked whether it's true, he said, I don't know.
If you're representing that party, what would you like the testimony to be?
That what they used to do or saying was false.
Okay. What else?
I didn't know that the person who had character that could use defamation proof.
Yes.
That was really interesting.
Yeah. Yeah. The court in the Davis case specifically found that plaintiff, in terms of his reputation, there was nothing there for the law to protect. His reputation was valueless, said the court. So yeah, you can sink that low and be defamation proof. What else? Yes, ma'am.
And a deceased person can't be defamed, but a business can.
Yes, correct. It might not be nice to say ugly things about the dearly departed, but it's not tortious to do that. What else? Anything at all, big or small. These are all really good. What else? Come on. 5 more people. Yep.
It's just the definition of inducement, innuendo, and colloquium. Am I saying that right? Colloquium?
Yeah. Colloquium. Some strange terminology that runs through the law of defamation. What else? Come on, keep it going. Or I can just start picking out names. 4 more.
Statements of opinion.
Statements of opinion can amount to defamation provided what? There's an express or implied assertion of a fact. That's right. 3 more. And we'll go on. Yep.
There's no requirement for the recipient to believe that it's true.
And in fact, the recipient of the information or the person that heard it or seen it, they can know that it's false. They can know that it's a lie. But still, defamation can attach. Yep.
Defamation only covers living people.
Right? 1 more.
You can't water down your statements and say, I think so-and-so, your example was a thief, and then say, well, that wasn't information.
Right. You can't hide behind, well, I think this is true, or it's my opinion that this happened. If there's an express or implied assertion of fact, even couched in a watered down statement, it still can be found to be defamatory. So, last week we did cover the first, I guess it's first 3 elements that make up a defamation case, whether it's libel or slander, either one. We did talk about the requirement at some length that there be defamatory language, as you all pointed out in different ways. That language has to be of or concerning the plaintiff. That is, it has to be about the plaintiff. And we covered, or at least started to cover, the element of publication, which does mean that the information at issue was disseminated to at least 1/3 person who understood it in its defamatory sense. So we begin tonight with this question: what if the plaintiff is the one who made the publication? Is that a valid publication for purposes of defamation law? And that does bring us to the first case, Sullivan versus Baptist Hospital. Mr. Maddox, tell us about this one.
So this case addresses whether Tennessee recognized the doctrine of compelled self-publication in defamation law, specifically whether the publication element is satisfied when a discharged employee is forced to repeat to prospective employers the allegedly false reason given by a former employer for their termination. In this particular case, Karen Sullivan was a full-time neonatal nurse at Baptist Memorial Hospital. While she was employed there, she also worked part-time at St. Francis Hospital through a staffing agency. Baptist became suspicious that some of its nurses were taking Baptist medical property to assist St. Francis in the development of their neonatal unit. And eventually the suspicion began to center around Ms. Sullivan. Another Baptist nurse, Susan Parsons, reported that Sullivan had admitted to her, supposedly, that she'd been taking neonatal IV angiocasts from Baptist for use at St. Francis. Parsons testified that Sullivan told her she had taken the newer angiocasts because the ones at St. Francis were older and not working as well. When confronted by her supervisor, she denied all the allegations, no theft, but she was ultimately terminated. And following her termination, she went out to apply to multiple other hospitals, Methodist Hospital in Jackson, Madison County, and she alleged that on those employment applications and hiring process, she was required to admit or to disclose the reason for her termination from Baptist. She conceded in the
And
complaint.
consequently, she wasn't hired, right?
Correct.
So if you were an employer and you read on your prospective employee's application that they were terminated from their last job for theft, would you be inclined to hire that person, or might you just go on to the next applicant?
Well, as somebody who's been an employer and has actually had this kind of issue come before me before, the answer is probably not, or at a minimum, I'd be doing some very significant additional background checks.
Okay. So she discloses this information.
Allegedly.
What?
I'm talking about Parsons.
She discloses this information. She doesn't get hired. What does she do next?
She filed for defamation against Baptist under the auspice that she was having to have compulsory self-disclosure of the defamatory statement.
And what's the response of Baptist Hospital?
They filed for summary judgment, and it was granted.
What's yeah, go ahead.
So trial court granted it, and then it was on the appeals court. They adopted the minority position of other states. That position was that self-publication satisfies the publication element when 1, the defendant can reasonably foresee that the plaintiff will be compelled to publish the defamatory statement, and 2, the plaintiff is in fact compelled to publish the defamatory statement on subsequent employment applications.
Is there any, did the plaintiff concede that she is the one that made this information known to a third person?
She did.
So there's no dispute that she did that.
Correct.
But her argument is, I was essentially forced to do it. I had no real choice. What was I supposed to do? Lie on my job application? And then if I did get the job and they found out that what the true circumstances were, they would just fire me then. Or if I didn't mention it in the application and the prospective employer called my former employer and was told, oh, we let her go because we think that she was stealing our stuff, she'd be in the same boat, right? She wouldn't even get hired. So her pitch to the court in response to the defendant's motion for summary judgment is that I had to self-publish. And the Court of Appeals, as you pointed out, essentially agreed that if the self-publication is compelled self-publication in the employment context, that's enough. That is a valid publication. The Supreme Court grants review in order to decide what question? What's the issue here?
The primary issue, or the sole issue, is does the publication element of defamation in Tennessee include compelled self-publication? That is, when a former employee is forced to repeat to prospective employers the defamation reason given by the former employer for termination. And also, should they recognize the minority rule from the appeals court?
So there is the minority view. Some jurisdictions do recognize self-publication on the part of the plaintiff as a valid publication for purposes of defamation. The majority of jurisdictions, though, then do not. Which approach does the Tennessee Supreme Court adopt for us? Majority rule or minority rule?
It's majority, but I don't know if it was more of an adoption or just reiteration of the existing precedent for the state.
So, well, let me ask it this way then. Does Tennessee fall in the minority view or the majority view when it comes to self-publication? The majority view. Why? Why did the court, what's the rationale for the court's decision?
Well, they relied heavily on the restatement of torts 508B, and said that publication is a term of art, meaning that communication of defamatory material to a third person is required. They relied on Quality Arts, Auto Parts versus Bluff, City of Buick, and then whenever you're into 100-year-old cases, Silvas v. Miller and Kansas v. Delaney, and really centered around the whole premise that the publication has to be given to the third party. And
Well, here it was given to a third party who understood it in its defamatory sense.
right, by the defendant has to be the one who is the one that disclosed it.
My question is why? Why did the court adopt the majority view instead of minority view, which the Court of Appeals
Why?
did?
Oh,
Yeah, what's the rationale for the court's
Which
decision?
element of the mental gymnastics they went through do you prefer?
I'm just asking you the question.
Okay, so one of their primary elements was they argued that Tennessee is an at-will employment state, and somehow that if they allowed for employees to be able to litigate against the employer, that somehow that would contradict the at-will premise, that it would somehow impact the likelihood of employers giving reviews to their employees and having ongoing communication back and forth. That was one of their primary kind of policy.
So that's actually two different reasons right there that the court decided this case the way that it did. One is, yes, Tennessee is an at-will employment state. And if you don't know, what that means is that employers can discharge employees for a good reason, a bad reason, or no reason at all. And the majority view is consistent with the at-will employment concept. So that's one reason. The other one that you mentioned is one that I think was weighed heavily in the court's analysis, which is that if employers, if employers could be held liable when an employee self-publishes, that's going to chill communications as between employers and employees. In other words, employers are going to take the position of not telling employees why they are being fired, because they know that if they give them that reason and then they go out and they tell somebody, well, now there's a valid self-publication. And so the court seemed to really be bothered by this situation where employers would just not give employees a reason. Just you're fired. Why? Not going to tell you, but you're fired. If you lost your job, wouldn't you like to know why? I think most people would. Well, lawyers who represent businesses would hammer away at advice to the effect, if you terminate somebody, don't tell them why. Just terminate him. Because at that point, you lose all control over who that employee, ex-employee tells. All they have to do is tell one person, and now one of the elements of defamation is satisfied. So that seemed to, as I say, bother the court. There's another reason. though.
I was referring to TCA 51-1. It's the law that grants employers qualified immunity unless they provide truthful, fair, and unbiased information about current or former employees, unless the plaintiff can show knowingly false, deliberately misleading, malicious, reckless, or discriminatory conduct. It does give a provision for the good faith is presumed, but is rebuttable on showing by preponderance of the evidence that the information disclosed was knowingly false, misleading, disclosed for malicious purpose, or disclosed in reckless disregard for its falsity or defamatory nature.
What's that mean?
Well, the qualified immunity aspect is saying that if you're an employer, in general, the lawsuit's not going to move forward unless the plaintiff can prove one of those factors I listed off, generally malice or the reckless disregard for the truth.
What if an employer's investigation, let's just stick with this case. What if it turns out that Baptist Hospital's investigation into this believed theft was negligent? The employer failed to exercise reasonable care. And it turns out that Ms. Sullivan had not stolen anything, that the allegations are false.
The qualified immunity is potentially mitigated, and
Careful.
I'd say it was necessarily, it's potentially there's an argument. But
Does this statute, would Baptist Hospital be entitled to raise this qualified immunity defense if it turns out that the hospital was negligent?
no. Can they raise the defense?
Mm-hmm.
Well, of course they can raise the defense. Doesn't mean they're going to win.
Let me ask it this way then. If it turns out that Baptist Hospital is negligent, does the immunity afforded under the statute apply?
No. They talk about that at the end of the case. That was one of the entire provisions of why they were not letting it go forward.
You sure?
I may be misunderstanding the way you're framing it, but
Well, I framed it three different ways.
well, the negligence was a matter of fact for a jury, right?
I like how you dug in your position and you're not going to give that up easily.
I think I may be misunderstanding. Here's what I've got. The court observed that under the statute, mere negligence was not enough to defeat the employer's good faith presumption.
Okay. So negligence is not enough.
Correct.
All right, now we're on the same page, I think.
I thought we were on the same page all the time. I guess not.
Well, if one of us is on one page and the other's on the other, I don't think it was the same page, but I think we're there now. So when you step out of this case, what's the big takeaway for you?
For me, it's that this case needs to be challenged.
Legally, what does this case teach you about the law that you didn't know? So you knew all these legal principles before you read it? This case didn't teach you anything you didn't know?
I'd read the textbook before the case. mean, for me, the key takeaway for me was I preferred the minority rule. It made more sense to me logically.
So this
In
case
context
did
of-
not teach you anything about the law that you didn't know.
I mean, it confirmed the self-publication rule that it has to be published to a third party by the person who's being accused.
Did you know before you read it that self-publication was an invalid publication most of the time?
I did not.
Okay, there you go. That's what you learned. Let's say I'm your client. I own a business, and I come to you and I say, I have this employee that I want to fire. And you ask me why. Ask me why. Because this person is bad for morale. This person, other employees don't really get along with. This person is late a good bit of the time. This person dresses in a way that I don't like. This person's hair is way too long for my taste. And I want to part ways. But I don't want to get sued. What advice might you give me?
I tell them that Tennessee's an at-will state. You can technically fire them for whatever you want, from a common sense, long-term protection of your brand, and just general common sense perspective. You probably want to make it as streamlined of a process as possible. So if you're not going to disclose it, you probably want to at least make it seem amicable. If there is something that could be raised, not necessarily in the court, but in public opinion, you probably want to get them to sign a mutual non-disparagement X agreement.
Oh, and I forgot to say, I think this employee took a tool out of my shop and put it in his truck and took it home. But I'm not sure. I think he did.
Under current Tennessee case law, do not tell anybody.
What is case law?
The lawsuits that have resulted in opinions from
What's an
binding
opinion?
courts, the ruling from the court. So appeals level or higher.
What's an appeals level?
You have your trial court.
Trial
First
court, I
level.
don't even know what a trial court is. Talk to me like a real person, not like a lawyer.
If you don't want to get sued,
Okay?
don't say anything bad publicly about your employee.
I love that. As a layperson, I can understand that. But when this smart lawyer starts talking about appellate review, opinions, and whatever else you said, it just goes right by me. Don't lose your ability to talk like a real person, because you will be interacting with real people every single day. And they will very much appreciate your ability to communicate in a way that they communicate. It's great you know all the legal stuff, the jargon, the legalese, the terms. It's great to use those in court when you're talking to a judge or maybe with opposing counsel. But check that stuff when you're talking to a client, to the extent that you can. So I really liked that advice. Well, just don't publicly say bad things about that employee. Excellent. Thank you, sir. Someone else, what advice might you give? Now, why the standing ovation? What was that about?
John Maddox over here.
Okay, all right. Well, that's interesting. What other advice might somebody give? So you're going to get these phone calls. If you represent businesses, you are going to get phone calls like this. Yeah.
So I missed that, I was in the restroom. What advice would you give to the employee or employer?
Employer.
Well, from the employer standpoint, I work in HR. So to build a case for unemployment, you do have to have documentation.
Unemployment, that's a loaded term. That means something significant to you HR/lawyers. Doesn't mean a thing to me.
Employees will always come back to try to get unemployment, and there needs to be a reason for it to get unemployment.
So were you in here for my hypothetical?
No.
Okay, well, I mean, that's, the facts matter. Basically, I want to fire somebody because they're bad for morale, they're late for work. I don't like how they look, their appearance. I don't like their hair, don't like how they dress. I know that doesn't sit well with an HR person. And I think they stole something from me.
You can get
Somebody,
them on the attendance.
huh?
You can get them on the attendance piece. Documenting.
Other, okay. What advice? Anybody? Yes, ma'am.
Back in 1999, when this case was decided, I was still a fast food manager, not a paralegal at that point. And our company policy, when someone was called to confirm employment and whether they've been fired or whatever, all we would do is confirm that yes, they worked there and that they were either eligible or ineligible for rehire.
So translate what you just said into advice to a small business owner.
Make sure that whoever is confirming employment.
Make sure what?
Make sure that whoever in your company is confirming employment status for previous employees does not tell anyone a reason, just whether or not they're eligible for rehire with their company.
So you're saying if a prospective employer calls me, I don't have to tell them why I let the employee go?
I know back in 1999, you didn't.
Okay, I like that. I like that. Anybody else? Yeah.
I'd say that seems like you've given me enough, even though you don't have to under Tennessee laws. I would say just don't go around telling the whole town like, stuff that you shouldn't be talking about.
Maybe even just don't tell one person.
Yeah.
Because you know, they don't know, but you know that all you have to do is tell one third person in order to satisfy the publication element of defamation. Anybody else have a thought on this? Yep.
One of the things that we used to do was make sure that there was a witness with you when you're gonna do the termination. And so you do the termination, and then to piggyback off of what they said, we only verify dates.
Here's a question. If you have a witness in the room, is that one third person?
Not for HR.
You do not have to divulge your reason for firing somebody.
That's right. Thought I saw somebody else. Yeah,
If you do tell someone, and there involves some fact, then it better be true, not just something you think was true.
which takes me, the lawyer part of my brain takes me right back to the language of that statute. What else? Anyone?
This is kind of jokey, but I would just tell him you're fired and walk out of the room.
You would tell the employee,
The guy who's asking for my advice, if I don't like the way you talk, I would fire him and I fired him and walk out of the room.
Fire him as a client.
You don't have any fun.
remember 1/3 of zero doesn't pay the overhead.
Just try to drive the point home.
This gets maybe taking this a step further than what we really need to go, but what if your client says to you, I want to fire this person because I disagree with his or her religious beliefs? Or their political beliefs? Or I don't want people of their particular race working in my plant. Yeah, I hear. Okay, the HR. You're going to bust, right? Yeah. Go ahead.
I give this presentation every Monday.
Every Monday.
Every Monday, 9 to
Tennessee is an employee at will state. I don't know if you were in the room when we talked about that, but you can terminate someone for a good reason, a bad reason, or no reason at all. Now, in that context, what were you going to say?
I'm just gonna say it. I work in construction. Construction is very sexist and racist. But I bring up the protective classes and with hiring and firing, mind you, I'm not HR director, I'm just a recruiter. But what I've seen is, like, for example, we're gonna let somebody go. It's not about their cause. It's literally documenting behavior, and attendance is like 90% of why we let people go. And so if anything comes up from a legal standpoint, we have documentation about that. We've never let go based on that I'm aware of. I've only been there 9 months, but I've seen it all. I hear it all.
I'll add one piece to the employment at will doctrine that you didn't see in the court, in the Sullivan opinion. You can terminate an employee, legally terminate someone, and it's not tortious, for a good reason, for a bad reason, for no reason at all, but not an illegal reason. And there are reasons that do violate public policy that can render an employer liable in tort. Not to mention employment law and all that. I'm talking about tort law. So there are illegal reasons that can trigger a tort remedy, and that's one of the topics that we delve into in some depth in torts too. So just planting that seed with you now. So yeah.
I was just going to ask, as far as the plaintiff goes for those certain situations, whenever, like what you just stated, they get fired for some illegal reason. How is the plaintiff supposed to actually prove that that's the reason? If that's, I mean, that's very difficult, you know what I mean, to prove.
Sure, it's very difficult to prove, because when you put that manager or that supervisor or the business owner under oath and you ask them, Well, did you terminate John because John is a Democrat or a Republican or whatever the reason might be? What do you think they're going to say?
I mean, I was gonna say.
They're going to be lawyered up. right?
I know they're under oath, but I mean, I don't.
They're going to be lawyered up, and they're going to say probably what their lawyer has advised them to say. And so you might subpoena the records that she's keeping and see if there's something in there that might corroborate your client's claim. But some of these cases, sure, they can be difficult to prove. Yeah.
Hi, I have a question. So with Tennessee being an able state, we talked about that. Is it where the employee is employed, or is it where the company is housed at? So like, say, for example, if the company is, like their headquarters and they're based out of Kentucky, but the employee works in Tennessee. So how does that work?
That's not anything that's controlled by tort law, but by interjurisdictional principles. And you get into, well, where's the principal place of employment? Where were they hired? Where the paychecks come from? Does the employee go to some other state for meetings? So it's a very fact-intensive inquiry where the courts have to figure out whether the law of state A controls versus the law of state B. When a company crosses state lines, it can get pretty complicated. But, I mean, those are some of the factors that the courts will look at. Yep.
All right, then I'm not being smart today, but you're my attorney. on this, I own a small business, especially a grocery store, butcher shop, DE or butcher shop. There's one down in Green Hills, another one down in Brentwood.
Is this a hypothetical or is this real?
No, this is it. So we've been in business for about a year, a little over a year now. But just several people know that sometimes we've said, hey, there's a reason behind it, there's no reason. Other times, there's no reason. Am I opening myself up for liability by making a distinction for, hey, we fired you for this, we're letting you go for this, versus no reason at all?
So sometimes you'll disclose the reason, sometimes you won't.
Sometimes, yeah.
My advice to you would be consistent. Yep. Pick one and stick with that. And if you ask me, well, which one would you pick if you were me? I would probably say, don't give a reason.
Yeah, I think that's the safe move there.
That's the safest course. Now, is it the best course for, employment purpose, business purposes? Maybe not. Because you may well get a reputation of being a difficult place to work, where the communication between employer and employees is not very good. And who wants to work in an environment like that? But if you're just asking me what is the safest course legally speaking, I think it's probably you just don't give a reason, which isn't going to go over well with the person across the table that you've just terminated, but that's their problem, not yours. Anything else about self-publication? That's an interesting subject, isn't it? Yes.
What is your opinion on the majority versus minority rule?
Well, I mean, my opinion doesn't make any difference, but I think that the majority rule is probably the better reasoned rule. I understand where the minority rule is coming from. I understand where the Court of Appeals was coming from in adopting the approach that it did. But I'm persuaded by the plural rationales that support the majority approach. Especially in Tennessee, because the legislature has already weighed in on this subject through that statute. And so if I'm looking at it from a court's perspective, my default is probably going to be, well, the legislature has already addressed the issue. So that body has declared the public policy in this area, and as a court, I'm going to largely stay my hand. All right, what if there is more than one publication? Does that mean then that there can be more than one defamation suit? The answer is, it depends. So the basic rule is that each one of a multiple defamatory communication to a third person by the same defendant is viewed as a separate publication. And so that defendant can be held liable for each of those publications. Say, for example, A falsely tells B, just to stick with that example that I started with last week. Let's say A falsely says to B that C is a thief because he once stole his money. And then a little while later, A tells D the same thing. Does C have one or two defamation claims he could bring? He's got two. Those were separate publications by the same defendant, right? So each one of a multiple defamatory communication by the defendant is a separate publication. That said, a single communication heard at the same time by multiple people is viewed as a single publication only. So if A were to falsely tell B and D, who are standing right there together, that C is a thief because he once stole money from him, now C would just have one defamation claim, even though there were two recipients of the defamatory communication. Also, each copy of a book or each copy of a newspaper or each television broadcast or radio broadcast, each showing of a movie containing a defamatory communication about the plaintiff is viewed as a single publication only. And so the courts have dubbed this the single publication rule. So, for example, if a movie is shown on national television that defames the plaintiff and 5 million people see that movie, the plaintiff has one defamation claim, not 5 million. Now, how about this question? This is an interesting one. Is there liability for merely repeating defamatory communications? Or, as our grandmothers might have said, gossip? Is there liability for republishing or repeating defamatory communications? Generally, the answer is yes. That surprises a lot of people. Generally speaking, the answer to that is yes. So a person who does merely repeat or republish defamatory language is subject to liability to the same extent as though they were the ones that originally published that. Any guesses as to why that is? Yeah.
It's as if it's restarting the statute of limitations each time.
By the way, that was one of the reasons in Sullivan that we didn't talk about. The court basically said that if self-publication was a valid publication, all the plaintiff had to do was just tell somebody else throughout the course of his or her lifetime, and that would then spring into existence a new defamation claim. But what about this idea that if you just repeat defamatory language, you can be held liable for that? Why would the courts go there? Why would that be the law?
You're still making a conscientious choice to do it.
Okay. But so what? You're not the original, you're not the one that put that false information out there in the universe.
But you put it out there again.
Okay. So what?
So you could be affecting more people than the original.
You might, yes, depending on what the circumstances are. And in fact, the last utterance of a defamatory communication can be just as harmful, if not more so, than the first publication. And the law recognizes that. And so, yes, merely republishing, repeating defamatory language can subject that defendant to liability as though they were the ones that originally published that. And so these defendants are called republishers. Now, make a distinction between these republishers and what the courts call secondary republishers. Secondary republishers are just mere conduits of information, just mere conduits of the defamatory communication. Like, for example, the mail carrier who delivers the letter with the defamatory language in it, or the bookstore that has the defamatory book in it. What about reporters? What about TV stations? What about newscasters? Radio programs? Are these republishers? In some jurisdictions, the answer is yes. Media defendants, and I lump all the above together there, reporters, broadcasters, TV stations, etc. They're generally treated as republishers. Now, a footnote here concerning Tennessee law. With regard to media defendants in Tennessee, there's no liability for defamation on this theory of republishing unless that's done negligently. So there is a false standard that the plaintiff would have to meet, at least in Tennessee, in order to hold that reporter liable for repeating defamatory language. And that standard is a negligent standard. So there is this special rule in some jurisdictions, and we're one of them, for media defendants. All right, so there's got to be defamatory language. That language must be of or concerning the plaintiff. There has to be a publication. And the communication at issue must be false. Falsity is a required showing. So maybe to say the same thing a little bit differently, truth is an absolute defense in a defamation case. Truth is a defense. And that's true even if the publication was made out of pure spite, to do the plaintiff harm, maybe. Truth is an absolute defense in a defamation case. Now, traditionally, the legal burden of proving truth has been on the defendant to assert as a defense. But in cases involving media defendants and in cases where the communication at issue is a, quote, matter of public concern, meaning it's something that's newsworthy, whatever that means, then the First Amendment requires that the plaintiff bear the burden of proving falsity as one of the elements of the claim. So if the defendant is a media defendant, or if the circumstances are such that it's newsworthy, that is the matter of public concern, the U.S. Supreme Court, construing the First Amendment, has held that the plaintiff is the one who bears the burden of proving falsity. Now, again, another little footnote here concerning Tennessee. In our jurisdiction, the plaintiff must prove falsity all the time, in every case. And it doesn't matter whether the defendant is a reporter or a TV station or some other media outlet. It's the plaintiff always bears the burden of proving falsity as one of the prima facie elements. Even when the communication at issue is true, and therefore there is no liability for defamation, that doesn't mean necessarily that the plaintiff doesn't have a tort remedy. That remedy might lie into something we haven't discussed yet, invasion of privacy, or something that we have discussed, but it's been a while, which is the tort of intentional infliction of emotional distress. Which brings us to the Hustler versus Falwell case. Miss Joyce, you came in late. You got that case for us? Okay.
Good evening, everyone. Good evening. How's everybody doing? All right, thank you. I'm tired too. My name is Lauren Joyce, and if I haven't had the opportunity to meet you, I would like to. Tonight I have the opportunity to present Hustler Magazine versus Larry Falwell. In one instance, we have Larry Falwell, who is a well-known minister and commentator of politics and
commentary on news, and public affairs. And then we have Hustler Magazine, who is a magazine that circulates their publications nationwide. Mr. Falwell initially files claims against Hustler Magazine. And those claims are going to be invasion of privacy, libel, and intentional infliction of emotional distress. Allegedly, Hustler Magazine interviewed Mr. Falwell, and allegedly he disclosed that he was having sexual relations with his mother or having rendezvous with his mother. So I can just imagine Jerry Falwell probably in the morning drinking his coffee and reading Hustler Magazine, realizing that he's been exposed for having rendezvous with his mother. Allegedly. So Mr. Falwell sued them, and even while the case was pending, they publicized it again. Hustler Magazine had this format where they would ask celebrities to go into their first time making sexual innuendos, making a play on words on sexual innuendos to advertise liquor. In November, they had an issue, and they chose Jerry Falwell to talk about his first time. Apparently, at each interview, they sampled everyone's first time, and then they used that format in video form into the magazine format. The issue here that I found was whether the ad's publication was sufficiently outrageous to constitute intentional infliction of emotional distress.
Okay, let's pause right there. Did this interview ever take place?
There's no record, but
This interview never took place. So Hustler Magazine, aka Larry Flint, just made this up and published it in the magazine. And Falwell sues for asserting the three claims that you mentioned. And while the lawsuit is pending, Larry Flint decides, I'm going to run it again. And so he does. The case is tried. This is a jury trial. What resulted trial?
So at trial, it looks like they did go for the invasion of privacy claim. And then they sent the other two claims for intentional infliction of emotional distress and libel to the jury.
So there was or was not liability for invasion of privacy?
There was
No liability, so that one's gone. Did Falwell recover for defamation? His libel claim?
He absolutely did. They awarded him.
Careful. Did he recover for defamation?
No.
No. Why not? What did the jury find as to the defamation claim?
I believe the court said that they treated it as not a publication that could be taken seriously or could be taken as true, especially when it mentioned twice that this isn't factual, this is kind of like for entertainment purposes.
So which of the elements that we've talked about so far did the jury find was not satisfied?
So that would be falsity.
So, right, well,
Or proving whether it was true or not.
so which element is that?
It
If the article,
notice?
huh?
Actual notice?
No.
No, sorry.
On the
I'm in another-
deficit.
I'm in another board, sorry.
Well, somebody help her out on that. Yes, ma'am, in the back.
Intentional infliction of emotion.
No, the question is, why did the jury decide the defamation claim against Falwell?
Against what?
Yes. He could not recover for defamation,
Right.
which is what you told us.
Mhm.
So which of the elements are a problem for him?
Oh, for him to prove.
Which one did he not prove?
That this is not true, like he has to bring forth evidence that this is not true. Since the burden's on him.
So, yes, but what element is that we've talked about? There was no what? You got 100 smart colleagues out
Oh,
here.
I'm sorry, y'all.
Feel free.
Was it because there wasn't a statement of fact that had the little disclaimers at the bottom saying it's not to be taken seriously as a parody?
So which element is that?
Awesome. Oh, go ahead.
Defamatory language.
There is no defamatory language. Falwell does not even get past the first element of defamation. That first element requires that there be what? An express or implied assertion of a false fact. And the court finds that there is none here. The reason that's so important is because it leads to the next question, which is whether he can recover not for defamation, but for intentional infliction of emotional distress. The jury did find in his favor on that, right? And awarded him, if you total it all up, it's something like $200,000 for intentional infliction of emotional distress. So he won on that claim at trial. Flint appealed that to the Court of Appeals, and the Court of Appeals did what? So the plaintiff wins the trial. The jury finds that intentional infliction claim in his favor. What's the Court of Appeals do?
Didn't they reverse it and?
No, Court of do what? What'd you say? Court of Appeals affirms.
Yeah, they have.
Now, in the Court of Appeals opinion, there is some testimony that is set out that is not in the U.S. Supreme Court's opinion. And in particular, Larry Flint is testifying, and Falwell's lawyers are questioning him. And when you are questioning a witness, the first question that you always ask is what? What's your name? Please state your name for the record. That's a harmless enough question, right? So Falwell's lawyers asked Larry Flint, please state your name, and his response was, my name is Christopher Columbus Cornwallis, IPQ Harvey H. Apache Pew. Now, when your witness starts off that way, you know it might be a rocky road you're about to travel. I think, just knowing me and how I respond in in certain situations. I think if I had gotten that response as Falwell's lawyer, I would have immediately turned to the trial judge and I would have said something like, Your Honor, would you please instruct the witness not to waste the jury's time, the court's time, all of our time, and direct him to answer the question. Falwell's lawyer didn't do that. And I would submit that was probably the right call. I would have made the wrong call under those circumstances. So the witness says, my name is Christopher Columbus Cornwallis, IPQ Harvey H. Apache Pew. I'd immediately turn to the trial judge and said, Your Honor, would you please instruct this clown not to waste everybody's time? Falwell's lawyer didn't say a word about that, just asked the next question. Why do you suppose, as a matter of tactics or strategy, that approach would be better than mine? Any ideas? Any thoughts?
Let's go back. John? What's your name? Ryan.
I mean, you just put him on the record as a liar. You know his name is Barry Flynn. He says his name is string of names. You know he just put himself in a position where if you need to prove perjury, there it is.
Stacy?
I think that's probably correct, but I don't know that in hindsight that I would have just gone on for that reason.
I was going to say he wanted, sorry,
Who's talking? Yeah, go ahead.
he wanted to get a rise out of them, so he wanted to get a rise out of the people, and by giving into him and doing what you had said, he would have felt empowered by just moving on or ignoring him.
Maybe. I don't think that's would be my reason just to go on. And I think it's a valid point. I think both your points are good. Yes, ma'am.
This publication is based on parity. By accepting his answers at face value, then you give it some credence and like it's very believable take on that.
I don't know. Who do you have in the room right here? Okay. You have the jurors. They're going to be deciding this case. I think it was a great move on Falwell's lawyer's part to immediately give the jury a sense of what this character is about. Here you are in a court, very formal proceeding. Those jurors have taken time off work. They're away from their family. They're downtown where they don't want to be. And you, witness, are going to just waste their time and be a clown? You don't have to say that. He said it. And then you just go on. I think that was a great move. I'd have messed it up. Okay, so that's how he answers the first question. My name is Christopher Columbus Cornwaller, IPQ Harvey H. Apache Pew. Then Falwell's lawyer asked, who wrote that ad parody? And his answer, Yoko Ono and Billy Idol. I'm like, okay. They're watching. They're listening. Did you want to upset Reverend Falwell? Answer, yes. Question, do you recognize that in having published what you did in this ad, you were attempting to convey to the people who read it that Reverend Falwell was, just as you characterized him, a liar? Answer, he's a glutton. Question, how about a liar? Answer, yeah, he's a liar too. Question, how about a hypocrite? Answer, yeah. Question, that's what you wanted to convey? Answer, yeah. Question, and didn't it occur to you that if it wasn't true, you were attacking a person in his profession? Answer, yes, that occurred to me. Question, did you appreciate at the time you wrote okay or approved this publication that for Falwell to function in his livelihood and in his commitment and career, he has to have an integrity that people believe in? Did you not appreciate that? Answer, yeah. Question, and wasn't one of your objectives to destroy that integrity or harm it if you could? Answer, my objective was to assassinate his character. It is no surprise to me at all that the jury found in Falwell's favor on the outrageous conduct claim. Given that testimony, if you're the plaintiff, you can't script that any better. You have the defendant saying in no uncertain terms, in publishing this communication, my objective was to assassinate his character. That's not in the U.S. Supreme Court's opinion, but it is in the Fourth Circuit's opinion, if you want to look that up and read it. Back to the U.S. Supreme Court's decision now, which is the one that really matters. What is the issue that the court has to decide?
So the issue is whether the ad publication was sufficiently outrageous to constitute intentional infliction of emotional distress. That's what I have to do.
What's the answer?
The answer is no, because the person working for them is recovering damages for.
So if somebody just makes up a story because they want to assassinate your character, they just want to make it up and put it on their platform for, I don't know what the readership at that time may have been for that magazine, but I'll bet it's, I don't know, I'm just going to say 1 million people maybe have seen that. Huh? And then it was published again, just in case you didn't see it the first time, here it is again. I mean, that seems to be pretty outrageous. Let's go at it this way. Did the court allow Falwell to recover for intentional infliction of emotional distress?
Ultimately,
No. How come?
they're missing that element of extreme prejudice.
Nope. Let me ask it this way. What's the rule that the court adopts?
How that even when the speaker of the right is motivated, What I gathered was that they made like a parallel to the cartoonist, case. And one, it couldn't be seriously taken as fact, and two, it's free speech. It parallels with the first amendment, so the severe emotional depression, like they wouldn't be able to even pursue it.
I don't know about that. So the court says,
He's a public figure.
okay, now we're on to something. And because Falwell is a public figure, what's the legal significance of that?
Essentially, you put yourself out there.
So what's the legal significance of him being a public figure? In the context of either defamation or in intentional infliction of emotional distress. What's the significance of that?
They have people have the right to talk about them. Or
Yes.
As a public figure, people can have form opinions and
Yes.
say them freely. In the corner.
His reputation is huge for his job.
Say again?
His reputation is huge for his job.
That is true. But isn't that true for most people?
But more for him.
Certainly for a preacher, yeah, I do get that. So here's the rule that the court adopts. The court says we conclude that public figures and public officials, so those are two distinct classes there. Public figures and public officials may not recover for the tort of intentional infliction of emotional distress by reason of publications such as the one here at issue, without showing, in addition, that the publication contains a false statement of fact made with actual malice, which the court defines as knowledge that the statement was false or with reckless disregard as to whether or not it was true. That's the rule that the court adopts. So we've established that Falwell is a public figure. That then means he must prove malice, and he wasn't able to do that, most fundamentally because of the reason that he couldn't recover for defamation, which was there's no reasonably believable false fact here. Case dismissed. So let me ask you this last question. If a public figure or a public official cannot recover for defamation, can they recover for intentional infliction of emotional distress? No. I said that was my last question, but this will be my last question for sure. What does this case teach you about the law?
Well, before reading this case, I thought a public figure or a public person could not sue for defamation at all, to be honest, because you are putting yourself in the public and opening yourself up for opinion. But now I do know what you can pursue and what you cannot pursue, what elements you can create.
So yes, public officials and public figures can be plaintiffs in defamation cases, but it's very, very difficult for them to actually recover because of the malice standard. That would not apply if you or I were a plaintiff in a defamation case. And the way the Supreme Court defines malice here is the defendant knew that what he was putting out there was a lie, or he did so recklessly. That is, there was a high probability that it was untrue, but he put it out there anyway. And I would add, although the Supreme Court didn't get into it in this case, that showing of malice must be made by clear and convincing evidence, which makes it even harder to meet that standard. Thank you, ma'am. This case well, way back when I think I was in my second year of law school, Falwell and Flint, as you may or may not know, these two guys actually became friends. And they would travel and go on a lecture circuit. And they would talk about their opposing views, worldviews, and their respective takes on the First Amendment, and certainly this case. Well, when I was a second year student, they came to UT Law School. And I distinctly remember that when Larry Flint pulled up at the law school in his limousine, limousines plural, he had a whole entourage, and he's this really colorful figure. I just thought to myself, this is going to be a clown show. And so they wheeled him into this big auditorium, and he was in his gold-plated wheelchair, and he was surrounded by scantily clad women, and bodyguards were at the doors, and I was thinking, yeah, this is definitely going to be a clown show. It was anything but. I was amazed, really, at how knowledgeable and conversant these two were about First Amendment law, defamation law. They talked about some of these nuanced concepts that we're talking about. And I remember Flint telling us, I forget the exact amount, but he has a whole team of lawyers, or did it this time. He had a whole army of lawyers that worked full-time for his business, and they primarily defended defamation suits and invasion of privacy suits all across the country. That was their job. And he said he spends, and this is what I don't remember, just millions of dollars a year just defending defamation cases. And so he was very in tune with where the lines are. And it was just fascinating to hear him and Falwell talk about this much celebrated U.S. Supreme Court opinion that all these years later, law schools all over the country still use to illustrate these points. We have 3 classes after tonight, and then your final exam. Next week, so we have 3 because of the change in the schedule. 3 classes and then the final exam. So what we're going to do next week, as we start bringing the whole year in for a landing, next week, all we're going to do is complete defamation. Nothing else. We're just going to complete the defamation material, which is quite a bit. And then the following week, we'll do invasion of privacy. And then on week 3, the last time we meet, we'll do the nuisance material. Okay? So that's going to take us through the end of the year. And I can tell you now that your final exam is going to be all multiple choice. It will be very similar to what you've seen on the other 2 exams. That format seems to be working fairly well for the group as a whole, so I think we're just going to stick with that to finish out the year.
Will it be the same amount of questions?
I'm sorry?
Will it be the same amount of questions, like the same set? Or will it be more?
I'm not sure just yet because I'm not done making it out. It'll be at least 50 questions. Your other 2 were 50, right? Yeah. Yeah, they were 50. Well, this one will be at least 50. All right. Well, make sure I get the roll. I'll see you next time.